Good evening, everyone, and welcome to the regular meeting of the West Covina Planning Commission for Tuesday, November 26, 2019. We will begin tonight with rising for a moment of silent prayer meditation, which will be followed by the Pledge of Allegiance led tonight by Commissioner Holtz. So please rise.
Okay. Please rise, place your hand over your heart, face the flag, and follow me.
May we have the roll call, please?
Commissioner Holtz?
Here.
Commissioner Hing?
Here.
Commissioner Kennedy?
Here.
Commissioner Jaquez?
Here.
Chairman Redholz?
Here. Next item is approval of minutes for our regular meeting of October 22nd, 2019. Any commissioners have any changes to those minutes? Hearing none, those minutes will be approved as presented. The next item is oral communications. This is where any member of the public can address the commission on non-agendized items. Those kind of topics we would have to defer because they're not on the agenda, but I don't see anyone wishing to speak on oral communications, so we will close that agenda item and move on to the public hearings. We have 3 public hearings scheduled tonight and 2 non-hearing items. So we will go to item number 2, which is a code amendment, number 16-03, general exemption, citywide location. Mr. Anderson, who will be giving the staff report on item number 2?
Our planning manager, Joanne Burns, will be presenting that report.
Thank you. Joanne?
Good evening, Honorable Chair, members of the Planning Commission, and also members of the public here and also at home. The item before you is for wireless a code amendment for wireless telecommunication facilities in the public right-of-way. With a little bit of background, on February 16, 2016, the City Council initiated the code amendment addressing wireless telecommunication facilities located within the public right-of-way. On September 27, 2018, the FCC order was released, which significantly limited local management of small wireless facilities in the public right-of-way. On April 2019, 2 things happened. One, the California Supreme Court decided on T-Mobile West, LLC versus City and County of San Francisco, which validated that municipalities can regulate the aesthetics of wireless facilities in the public right-of-way. Because of that, the Planning Commission, the West Covina Planning Commission adopted design guidelines for small wireless facilities in the public right-of-way, which required to be published in advance. On May 14 and July 23, 2019, the Planning Commission held study sessions on small wireless facilities in the public right-of-way. On July 23, 2019, the Planning Commission reviewed and approved five administrative use permit applications for small wireless facilities in the public right-of-way, proposed on top of replacement light poles, all located within the Woodside Village area of the city. This decision was later appealed. The appeal was filed on August 5th, 2019, and the City Council on October 1st voted to overturn the Planning Commission's decision and deny the administrative use permit applications. Since the code amendment was prepared in response to the Planning Commission, the study sessions, and the comments provided by the Planning Commission during the study sessions, this draft code amendment includes only those that the Planning Commission directed staff to include in the code amendment. This code amendment process is essentially three parts. The first part already occurred, which is the study session. The second part is occurring right now, which is basically the code amendment. The Planning Commission today will review a draft ordinance that the Planning Commission can recommend that the City Council adopt. And the third part is to update the adopted design guidelines for wireless telecommunication facilities in the public right-of-way. This is mainly because most of the items contained within the draft ordinance addresses the process of reviewing small wireless facilities in the public right-of-way, the location, and also general standards on how it should be maintained. It doesn't provide any standards or any, it doesn't provide any design standards on what they should look like. So this is why the design guidelines do need to be updated to be consistent with the ordinance. Before we go on with the draft code amendment, I would like to review what the current code allows or how the current code addresses wireless facilities in the public right-of-way. So basically, the only code section that talks about wireless telecommunication facilities is in the zoning code in Division 16, which is entitled Wireless Telecommunication Facilities. But in its purpose, it talks about regulating wireless telecommunication facilities within all land use districts or zones. There is no zoning for the public right-of-way, so the public right-of-way in itself is not zoned. And furthermore, in this code section, it addresses exemptions, and one of the exemptions is wireless telecommunication facilities owned and operated by the city or other public agency when used for emergency response services, public utilities, operations, and maintenance. In this instance, a lot of or many of the wireless telecommunication service providers are considered public utility providers by the Public Utility Commission. And also in section 26-685.984, it talks about prohibited wireless telecommunication facilities in residential zones. And it brings up the exemption. So basically all wireless telecommunication facilities are exempt from residential zones except, and there is number 2 in the exemption, which is wireless telecommunication facilities attached to light poles, utility poles, traffic signals, and similar structures. Before April 2019, applications for wireless telecommunication facilities in the public right-of-way were just submitted to the engineering division and were allowed through merely an encroachment permit process. Aesthetics were not considered at all. After the Supreme Court validated the local government could regulate aesthetics of small wireless facilities in the public right-of-way, the Planning Commission immediately adopted the design guidelines, and so now we are able to regulate aesthetics of wireless telecommunication facilities in the public right-of-way through the administrative use permit process. The city does have about, I believe, 7 wireless telecommunication facilities in the public right-of-way, and here is a map. The green dots show the location of the wireless facilities that are existing in the public right-of-way within the city. The northerly one is located on Azusa, just south of Puente, and then the one to the east is located on Grand Avenue near Cameron Avenue, near its intersection with Cameron Avenue. The other ones are located within the Woodside Village area of the city of West Covina. If I could note that since there are many small wireless facilities in the Woodside Village area it's mainly because it's one of the densest residential areas in the city. So in this case, wireless providers feel that it's more needed in this area. And I'll go ahead and go over what those existing facilities look like. So on this one right along here to the left is located on the corner of Nogales Avenue and Amar Road. And you can see where the red arrow is, that's the antenna, and there's the box on the side of the pole. And similar to that design, there is one on Nogales near Shadow Oak. Again, antenna with the box. And these are the other small wireless facilities within the city. This is located on Grand Avenue in Cameron. The antenna, the box, and I believe these wires are for the antenna in the facility itself. And this one in the middle is located on Vincent Avenue, south of Puente Avenue. As you can see, there are antennas, several antennas, and the boxes near the facility, or for the facility. And the one to the furthest right is located on Shadow Oak Avenue near Shadow Oak Park. The antenna that's shielded with a small radome, and the box, and I believe these boxes are also for the facility itself. So these were submitted prior to April 2019, prior to the Planning Commission adopting the design guidelines for small wireless facilities in the public right-of-way. And I'll go ahead and go over the Planning Commission adopted design guidelines. So the Planning Commission adopted design guidelines indicate that the location has to be 100 feet away from properties used for residential purposes. And it states that facilities should be proposed on existing aggregate light poles. And if a replacement pole is going to be proposed, it has to be at least 3 feet away from the existing light pole. And it has to match the aesthetics and consistency of all other light poles within the area. The alignment and the enclosure, as far as the radome to shroud the antenna itself, has to be at a rate of approximately 1:1 for a more visual streamline effect. All antennas and RRUs have to be shrouded on top of the light pole. Wireless and cables have to be contained within the shroud and run inside the pole. You can't have the poles or the wires showing from the outside of the pole. Signage is at the minimum required by the government, and the equipment itself has to be undergrounded. The height of the overall pole can exceed 35 feet or has to be similar to the surrounding poles in itself. So basically, just because you don't comply with the design guidelines, it doesn't mean that it would not be allowed. It's just that the design guidelines is for an approval recommendation. The AUP application can be approved directly by the Community Development Director, or it can be referred or approved by the Planning Commission. So if it doesn't comply with the design guidelines, it goes to the Planning Commission. If it does, staff can approve it through an administrative use permit process, which requires public notification of all properties within 300 feet away from the site. So let's go ahead and go over the proposed code amendment. The first portion of the proposed code amendment is Division 3, which is the conditional use permit section. This clarifies that the existing conditional use permit findings are for projects located within all land use zones, which are areas with a zoning designation. Again, the public right-of-way does not have a zoning designation in the zoning map. This is because there are separate findings for wireless facilities located in the public right-of-way in the new section. And this cross-references that section so that anybody that's looking at the conditional use permit findings and processes will be notified that there is a separate finding for wireless telecommunication facilities in the public right-of-way, so it's easier to find. In Division 16, wireless telecommunication facilities, this clarifies that the existing section will not apply to wireless facilities in the public right-of-way, and it also cross-references where standards for wireless telecommunication facilities in the public right-of-way can be found, which is the newly created Division 29. So in Division 29, Division 29 is a newly created division. It identifies that the planning director as the person responsible for administering this division. Right now, Jeff is considered the planning director, although his title is officially the community development director. We left the planning director title here because the rest of the code identifies it as the planning director. So it's just for a matter of consistency. And in the definition section for this division, it identifies that the planning director is the same as the community development director. It requires an administrative review application for minor wireless telecommunication facilities, which are identified as small wireless facilities or eligible facilities that comply with adopted design guidelines. The definition for small wireless facilities, we obtain them from how the FCC defines small wireless facilities, as well as for eligible facilities. So basically, eligible facilities are existing facilities that they're doing minor modifications to. And these facilities have to be located at least 250 feet from another wireless telecommunication facility and or at least 250 feet from a proposed wireless telecommunication facility within the same application bundle. I say application bundle because if they're applying for small wireless facilities, they're allowed to bundle them up in, I believe, 5 different applications, as long as they're within the same general area and as long as the proposed design is exactly the same. And then it requires conditional use permits for wireless telecommunication facilities that do not qualify for an administrative review. So if it doesn't meet the minor wireless facility threshold, then it's automatically a CUP. And that is also referred to as major wireless telecommunication facility permits. The code amendment identifies that the planning division, planning commission, and or city council approval does not constitute an encroachment permit and or the issuance of permits from other city division departments or government entities. So although if the project is approved by the planning commission or the planning staff or the city council, it doesn't mean that they can start construction right away. They still have to apply for an encroachment permit that is issued by the engineering division. And also, if the fire department has any requirements, they also have to comply with those as well. Identifies application submittal requirements and application review procedures. So it identifies, it doesn't necessarily say how much the application fee is, but it says that they have to pay the application fee. They have to completely fill out the application. They have to submit construction drawings or plans, a site survey, photo simulations, project narrative and justifications, an RF compliance report, proof of regulatory authorization, site agreement, acoustic analysis, wind load analysis, and so forth. It identifies design and development standards, including concealment requirements, and then in this particular area, it references the design guidelines. Its location, which is, it would not be allowed in any center median. It has to have a certain setback from residential structures. It has to meet the noise, it has to comply with the noise ordinance. They have to replace landscaping or supplement landscaping, or install supplementary landscaping. And their accessory equipment has to be undergrounded, and it can only be mounted on a pole as the support structure in itself. And it cannot obstruct any public right-of-ways that would cause a public safety concern. I'd like to point out in the draft ordinance in section 26-685.11600, that's subsection B. In number 2, SWF, small wireless facility, shall not be located. It says in there, I wrote in 10 feet. It's actually, that was a typo or a mistake. It's supposed to be 15 feet from any structure used for residential purposes in the PCD1 zone. So again, it's supposed to be 15 feet instead of 10 feet. This was the Planning Commission's direction in the PCD1 zone. So basically, the way the Planning Commission's direction was regarding setbacks from residential properties is that to tier it based on the required mainly based on what's the required front setback for properties or for structures within particular zoning areas. In the PCD1 zone, structures have to be at least 10 feet away from, residential structures have to be at least 10 feet away from the front property line. So 5 feet was added onto that. So the requirement or what's being proposed is 15 feet from any residential structure in the PCD1 zone. Yes. The PCD1 zone is the Woodside Village portion of the city. That's the zoning identification in the zoning map.
So for that particular area, it's 15 feet versus the rest of the area is 100 feet?
No, the rest of the area is number 3, 30 feet from any residential, for any structure used for residential purposes. So in other residential zoning areas, the required front setback is 25 feet. So it's another additional 5 feet from the required 25 feet front setback. So that's in other zoning. Yeah, in the PCD1, it's 10 feet. So
there's a whole litany of different standards in PCD1. The lots are smaller. They have smaller setbacks, so all we did was tack 5 feet onto the front setback. And that was discussed at the study session we had here. And the Planning Commission gave us direction to go forward with that.
And then moving forward, it identifies the operation and maintenance standards. Basically, the facility has to be maintained in good condition, free of any paint. The paint can't be chipped. Basically, has to be maintained well. It also outlines procedures for permit expiration, abandonment, removal, and legal nonconforming facilities. So it states that permits are only good for 10 years and before the 10 years, they can, providers can apply for an extension, or they can reapply for a new permit. And what's next? With this, staff recommends that the Planning Commission adopt a resolution recommending approval of Code Amendment 1603 to the City Council. Staff also recommends that the Planning Commission update the design guidelines for wireless facilities in the public right-of-way for City Council adoption. The second recommendation is not for today. It's for something that the Planning Commission should do, or staff recommends that the Planning Commission should do in a future meeting, in a future public hearing. If the Planning Commission has any questions, I'm available to answer.
Thank you, Joanne. Questions of staff? No? Okay, I'll go ahead and open the public hearing after hearing the staff report. The city's the applicant, right? So we've just heard from the applicant. Yeah, okay. All right.
Actually, Joanne,
Question?
yeah, I do have a question. Going back to this, can you pull out the graph for the design review? The small wireless facility design guidelines?
Mm-hmm.
So if you look at facility and support equipment, can we see it?
Yes.
It's basically saying that something similar, but 16 in diameters.
The maximum.
The maximum,
Yes.
correct?
Yes.
So you're saying that, let's say that if a lamp post, because our regular lamp post is about 6 inches or so. I don't exactly know, but about 6 inches. And then it tapered to the top portion where the light is at is about 4 inches or so. So it's probably double the size of this particular bottle, give or take. But then we're talking about this particular, you're saying the base pole maximum is 16 inches diameter. So they can balloon up this particular, or any particular pole or lamp post, or the new one, all the way up to 16 inches in diameter, which is about 4 inches bigger than my name tag right here. So it's bigger than this. How is that going to look similar to existing lamp posts throughout our whole city? I mean, that itself is not very similar per se, because if you have the whole block with about 6 inches of pole, that's very similar. And then you have every so many feet with maximum 16 inches or so of a diameter, so that's not similar to that extent. The other thing was the overall heights.
Why don't we take one question at a time so we don't get confused here? What you're reading is the base of the pole, not the top of the pole.
Correct. The base of the pole, ideally, it probably, I don't know if it's going to taper, but I doubt if it's going to be similar to the lamp post that is adjacent to the particular new one.
Well, I didn't know we were going to get into the shapes of these poles, but I do believe that they're more than 6 inches at the base. I think that's a norm. I don't know what it is, but I think the 16 was chosen because that's a fairly standard number for the base of a pole.
Well, actually, I have
We can look into that if that's, I don't know if I want to get bogged down in minutia for things that we're just guessing about, but we can research that if there's something that the Planning Commission wants to know, because obviously we have the resources to do that. I don't know the answer to that right now.
Okay. So, yeah, I mean, that's something that we need to discuss, because who come up with all this, like Planning Commission design guidelines? Like, how do we have...
Well, the Planning Commission adopted those in April.
I understand that, but how did this document come about to the Planning Commissions? And also regarding the item number 29, like all the wireless facility, Division 29, if you look at that division, which is the wireless telecommunication facility in the public right-of-way, who come up with the verbiage, all this? This is the first time I've seen it. So I'm just curious, because if we're approving something, I'd like to know how did this document come about as of today, since it's going to be new. Is that correct? Is my assumption correct?
So whenever, let's just talk about code amendments in general, because you got several tonight, and they all went through the same process. So we have, first it's initiated by either the Planning Commission or the City Council. So someone initiates it. It has to be the Planning Commission or the City Council. So in this case, I don't even remember who initiated it. It was just, I think it was the Planning Commission. Planning Commission initiates it. We have a study session, which we did for this one on July 23rd. We have a study session. You give us direction on how to prepare it. We work with the City Attorney's Office, that's why Barron's here, and then we prepare a code amendment and bring it back to you at a public hearing.
Well, I know the process in that respect that you had mentioned and go through. I just wanted to understand Division 29, as we're looking at it right now, for the wireless telecommunication facilities in the public right-of-way. This one is a newly added division.
It's brand new for your review tonight.
Okay,
not in the code.
I just wanted to see who came up with all these items, like the bullet points, new division created. Well, obviously, it's new division created. Like all the other items, or the bullet points on this one, who came up with it? Because this is the first time I've seen it. I know we're going to go through our discussions, but I just like to know who put this together.
The Planning Commission gave us directions on generalities, and then we put it together, and Barron may want to answer some of that, why some of the things are there, but we basically rely on federal law.
Because as a planning commissioner, this is the first time I've seen it, and I don't remember we have all these bullet points given to you guys. I'm just curious in terms of how did this
So I'm
document
just trying to be
comes about.
clear that
Yes.
every time we have a public hearing, it's the first time you see a code amendment. You can't see it before we prepare it.
Okay.
So this is the first time you've seen it because we just got done preparing it.
Okay, so this, so far, the bullet, can you pull up that bullet, Division 29? So bullet number 1, obviously it's a new division created. Bullet number 2, it identifies the planning director as a person responsible for administrator of the division. So
that's the entire zoning code. The planning director is responsible for administering the whole entire zoning code. So that's consistent with the rest of the zoning code.
Okay, so basically the planning department come up with this document, basically.
So basically,
So far,
the way
as of
I guess ordinances come about is that staff initially drafts it based on comments provided by the Planning Commission, and then we provide the city attorney's office a copy of it so that the city attorney can review it to make sure that that's legally defensible.
So in another word, staff created this document right now that I'm looking at, which is Division 29. All the bullets in there is created by staff. And then every single bullet in there, it's up to the Planning Commission to decide and make adjustments to it. Is that how I...
The entire ordinance, yes.
Entire ordinance?
Yes.
Because I just want to make it clear, because as a planning commissioners, this is the first time...
The city council has ultimate authority.
Of course, of course. Yes, I understand that. But I just wanted to understand at this point, as a planning commissioners, this is the first time I've seen it, and I just want to understand how and who came up with all these bullet points. And also to understand as a planning commissioners to see what we can make. So each of those bullets, we can actually potentially make adjustment or changes to them.
Yeah.
Given, obviously we have to take the feedback from the publics and from the residents and all that. That's why.
Certainly. Baron Bettenhausen, City Attorney. Absolutely. You have discretion to fine-tune, tweak, change substantial provisions of the ordinance. I will just add the caveat that it is your planning staff who are in the technical weeds, so to speak. So when they prepare this with an more of a deep-level understanding of the law or the engineering and the planning aspects of it, in conjunction with my office, where we kind of look at the legal aspects of it, you absolutely have discretion to change things if you want to. If necessary, continue the matter to look at it deeper, set study sessions. All these are within your discretionary authority. When you give direction to your planning department, they develop it with their technical knowledge and then conjunction with my office with our legal knowledge, and then we bring it to you for that consideration in the public hearing to do whatever you wish. Adopt it, continue it, change it, request changes, in which case it would come back to your planning staff for changes, and we bring it back to you again.
I guess, thank you for clarifying that, by the way. I'm just not, I guess, particularly clear in terms of if we were to adopt all this bullet point on this particular division, it appears, I don't know yet at this moment in time, and we haven't have a discussion or vote on it. It appears like the planning directors, or what do they call? Yes, the planning directors ultimately have all the say in this particular small white, wait, hold on, let me finish first. So if we were to adopt this particular division 29 tonight, it appears to me, we haven't had a discussion yet. That I understand, and we haven't had public input yet. That I also understand as well. But it appears to me, just looking at it right now, that it identifies as the planning director oversees all this wireless facility. And also, it also appears to me that the only person that have somewhat of a say is the engineering department, just to make sure that they comply with the streets and safety and all that stuff. But I guess my concern is, when will the residents have an input after these adoptions of Division 29? Now, we are making this particular division affecting every single household or every single property in the city of West Covina, and it just appears to me, as I was going through it, that one, the city, there's two departments, whether it's the planning department oversees it or approves it, and then it just passes it along to the engineering divisions to get final approval in the fire department. So I guess my question is, at this very point right here, when will the resident have a say if they have an issue? Like, let's say, will there be a bullet point to say, hey, if one resident come up to them and say, look, I don't like this in front of my house or my property, will they have a say? Or should we have something in there to give it a voice? But I mean, like, again, I may jump to a conclusion that, but it just seems like if we were to approve this tonight, it appears to me that this may be an issue. Whether we're giving it to one or only city staff to have, you can say, make all the decisions for the entire city's public right-of-way. And another thing that I'm not clear, which I probably need you to clarify, is regarding zoning code. Because right now, zoning code is very particular in terms of residential zone is residential zone. But then right now, I'm not sure how this is going to work out, but it seems like the public right-of-way all of a sudden is no longer residential zone. It appears. Again, we may have a discussion about this, but I'm very particular. Like, if someone wants a taco truck on the public right-of-way, then all of a sudden they can't do it because it's no longer residential zone. I'm just curious. This is just something that, okay, it may not be true, but regarding this particular item, I like to, clarify. We can't just designate an area that's residential zone, commercial zone, or industrial zone, or manufacturing zone, which is like, it particularly has different zone for different function, different purpose. However, tonight what I'm hearing is residential zone is divided up into the street section and then the resident area. So that's something that I also like to have a discussions about.
Can we, Commissioner Hing, you've asked a lot of questions, made a lot of comments. Can we let staff address some of these?
Yes.
Can we do that?
Yeah.
Thank you.
If I may address some of it, and forgive me if I miss some, remind me. At the higher level, these are good questions, and it's some higher level discussion. This public hearing is the opportunity for the public to come in and comment on the process. When we're adopting zoning code, you guys that is your input on what the law is. And when we say that the planning administrator administrates the code, we're basically saying he's the police officer enforcing the law that you guys are setting. So we're saying, well, we're giving all the power to staff. In reality, we're giving the power is yours to set what the law, or in this case, the zoning code is. And the reason why we have to do it in this specific circumstance is because federal regulations, and specifically the the FCC's third declaratory order, third report and order, which came out in 2018, requires that small cells be done at an administrative process. Administrative process means that it's over the counter with staff, not CUPs, not coming to the Planning Commission. That's required under federal law. So we have to move some of that. We have to move some of that under the planning director's authority. And that's what we're trying to do while simultaneously retaining as much authority for you guys as possible to enforce your community standards. And again, this public hearing is your opportunity to say what those community standards are. Now, if there are concerns raised by the public in the future, there's always the opportunity to bring an ordinance or zoning code back and say, you know, that's not working out so well, let's tweak that. And planning staff will look at that. My office will look at it to make sure that we could tweak it while still complying with the law. And we'll do that to address those community concerns, because we certainly want to be sensitive to the community. I think I've answered all of your questions.
I actually have another one since you had addressed this issue. You're saying that we're writing these codes to adjust to what the FCC want, but also at the same time you had also, well, staff had also mentioned that the state Supreme Court had stated in California, I believe it's California Supreme Court, correct me if I'm mistaken, had also stated that we do as a city can regulate how we want the aesthetic of our cities to look like. Is that?
That's correct.
And also, before you answer that question, can you also answer another question? The Federal Appeal Court recently in August, did it not stated that regarding the small cell, I read some documents that small cells has to be stopped because unless they can come up with some type of environmental studies. Is that something, it's in August, so I'm not sure. Anyway.
August of this year, and you're referring to environmental reports. That's in the process, and that's not really the subject of tonight. There are environmental requirements in our current ordinance.
You can just ignore the last part of it. Okay, so we just talk about the federal, the FCC, what the FCC we want, and also address the Supreme Court of California. Yes. How is that going to affect us, and what type of decisions we can make? Because the Supreme Court of California, I get the two mixed up between the federal and the California, that basically is stating that as a city, we do have a lot of control, actually, in terms of aesthetic-wise, how we want our zoning code and how we want all these facilities to look among the residents and among...
You're absolutely correct. You do have control when it comes to aesthetics. Now, and there is tension there, okay? So you've got federal regulations, you've got federal laws, you've got state laws and state regulations, all which have to be balanced. And again, that's what your planning department in my office is doing when we're coming to you with these ordinances. There is a case, in which the staff has cited to and we're familiar with, about how cities do have control over aesthetics. You can impose reasonable time, place, and manner restrictions. You can require a pole to move a little bit, which is part of these ordinances. When we're talking about 10 feet or 15 feet, that would fall under your ability to control aesthetics. That has to be balanced against what the federal government has required, and specifically the FCC, in stating that when you're imposing standards, they have to be reasonable and published in advance, so we can't impose them on the fly for each individual application. And again, I'm specifically referring to small cells, which is what they're saying has to be administrative. So they have to be published in advance, reasonable, objective, and they have to be equally applied to other infrastructure. That's what we're trying to accomplish by in advance saying these are the standards we want are going to force these carriers to comply with. That's why we're here tonight, to try and impose that. Now, this is also your chance at simultaneously saying these are our aesthetic values. We want to make sure they're stealthed. We want to make sure that the poles are not too wide. That's where your control over aesthetics comes in. We cannot, on an individual basis, for some of these applications, some we can, and that's, again, built into the code when we're trying to make it as expansive as possible when you can have a CUP, when it will come to you every time. But there's some circumstances where it has to be administratively issued, and that's what we're trying to put forward now.
But Okay, I understand that regarding what the FCC wants. I also wanted to ask you regarding what, in terms of zoning code and how the city was allowed to zone where we can put these type of facilities. So you mentioned 10 foot, but according to what I understand is that it's not so much of a distant-wise, it's an area of the city, whether you can allow it or not, like historical area. Not exactly sure if West Covina has one, but let's just say, assuming that if West Covina does have one, we can zone that particular area, hypothetically. We can zone in certain areas to have this type of facility or not have this type of facilities.
I'm not sure which authority you're looking at. I will say that federal law is pretty clear that you cannot impose a prohibition or what's called an effective prohibition. What they mean by effective prohibition is where you impose standards and requirements so onerous that they can't put it there. So I would say that you cannot
Well, we have
carve out a
17
zone where
acres,
they
so
can't
city of
install.
West Covina is not a small city, so obviously we can't, 17 square miles, I'm sorry, did I say square feet? 17 square miles.
I'm sorry. You mentioned historical structures or historical areas. In the draft ordinance, there is a section there that says that these small wireless facilities have to be at least 100 feet away from historic structures.
Okay, I'm going to use my discretion as chair and move the hearing along a little bit. And I think it's time to open it up for public discussion, have to hear from the public. I'm going to call those in favor. I only have 2 cards on this. If anyone else wishes to be heard on this, either for or against, I need a card, okay? Stating whether you're for or against. Right now, excuse me, I'm going to call the people in favor. That would be Robert Gistad. Is that correct, sir? Please come forward.
Good evening, Commissioners. Robert Gistad. I'm a network real estate manager with Crown Castle, and I spent a good chunk of the day reading the ordinance. I am in support of the ordinance generally. I think there's a lot to be worked on, and I know what we want to do is we want to sort of put more detailed thoughts down in writing and submit it for sort of additional review. So we will do that, but I do have some kind of higher level thoughts about the ordinance. I think the major focus of the ordinance is a distinction between major wireless facilities, major wireless small facilities, and minor small wireless facilities. And I think the concept is that if it's minor, then it basically complies with the standards in the ordinance, it complies with the design guidelines, and therefore the process should be simpler, right? If it doesn't comply in some way, then there's more of a challenge. I guess the question I have is, in setting that distinction up, what is the city's ultimate goal? And from our perspective, obviously, if we are complying with the ordinance and with the setback requirements and size limitations and other kinds of things, the process should be very, very simple. It shouldn't be that regardless of what you do, you end up in zoning, and you can clarify if I'm incorrect about this, but with the possibility of appeal. I mean, I think, Commissioner Heng, to your question about residential involvement, the answer really is sort of the role of appeal and the ability to come in and question, a particular application. But if there are applications that the city, has determined through this expansive process, and this process is not simple. It's not just tonight. It's going on weeks and weeks, and it probably will go on additional weeks and weeks. the city will determine what kinds of facilities, what locations are by their nature acceptable to the city. If that's the case, the process should not engage the possibility of appeal, so that those same facilities that comply with the design guidelines find themselves facing the Planning Commission on appeal with a group of residents who just generally happen to oppose wireless facilities. So one recommendation is to take a look at major versus minor and really identify what process achieves the result that the city wants. And I don't believe the city wants hundreds and hundreds of hearings on individual locations. So if there's a way to, I mean, administrative planning review is certainly a little bit easier than going to the Planning Commission and appealing to City Council, but it's not the same as, you know, if we come to a pre-application meeting, and one of the things that's discussed is the idea that that we're encouraged to come for pre-application meetings. Sit down, talk about the design, where it is, what we want to do, right? That feels like a work around the shot clock, unless there's a real benefit. And the real benefit would be that if at that pre-application meeting there is a determination that the facility complies with the standards, then that application should get the check off from the planning department, and it should go to Public Works and get approval for construction. It should be very simple, because you have already taken all this time to identify that those facilities are acceptable. So to subject those to further discretionary review, however minimalized that might be, is a waste of the city's effort. That's a thought. And then I wouldn't go so high even as to require a full CUP. If there's a question about compliance with the standards, then why not have the director review that, make a determination about whether have the discretion, have the authority to make a determination on that application that is then appealable, so that if there are residents that are unhappy with that particular decision, that's when it comes. The idea is to really narrow, the number of times that you're facing the same question over and over and over again, and you will continue to have that. And we don't want to be in a situation like we were before, where we felt we complied with the design guidelines, you guys approved our permits, and the next thing we know, we had a circus at City Council. There's no reason for that. There's a couple other things. Kind of forced waivers. Am I done?
Your time is up.
Okay.
But I do have a question for you, though.
Sure.
Staff showed some pictures of facilities, on the south side of the city. Are those Crown Castle?
I know that we've had one facility that's been approved here. I'm not sure if all of them were. We have an agreement. We bought a company called NextG, and NextG installed DAS facilities. So I think there's a chance those were NextG facilities. I know for sure that in the last couple of years we've constructed a single facility, but the older 10 years or 8 years ago, whatever that was, they may be NextG, but I'm not certain.
Okay.
Okay?
Yeah.
And I'm happy to answer any additional questions you have.
Okay. Thank you. I just want to, before we move on here, I just want to, just for clarification, the process that we're going through tonight, initiating this code amendment, is this process any different than any other code amendment that we would process in the past? Is anything unique about this that makes it different?
No, not really. I mean, we got 2 other code amendment hearings tonight. They followed a very similar process.
Okay. And as the Community Development Director / Planning Director, it's your job to oversee anything and everything to do with the zoning in this city, correct?
Yes.
It's not just
No, it's
wireless
not just
facilities.
this. It's house additions, it's uses that we do CUPs for, it's new buildings, all those things we look at before the Planning Commission ever sees them.
Okay. And as far as the public being able to be heard, this hearing is a public hearing, correct?
Correct.
And was it not noticed?
It was published in the paper, yes.
As is usual?
As is the norm, yes. I mean,
Nothing
it's required
different.
by law.
Okay. So all of those burdens have been met?
Correct.
By the city. Okay, so the public's opportunity to be heard, at least in the initial adoption of this code amendment, is tonight, and this is their chance, correct?
Correct.
Unless, in the future there's individual appeals on particular items, then they can be heard on that also, correct?
Now, there is a difference between, if I'm using the terminology correct, from the minor ones to the major ones. There are some that would be done at a staff level, but the major ones require a CUP, which, as you are aware, comes to the Planning Commission.
Right.
So those would be noticed and come to the Planning Commission for a hearing if they didn't comply with whatever guidelines are established by the City Council.
Right. So the public has more than, in other words, the public has ample opportunity to be heard, not only on this, but on any other ordinance or code amendment that would come before this commission. They have the opportunity to be heard every single time. And tonight is no different.
Correct.
Okay. Is there anyone else wishing to speak in favor of this code amendment tonight? I don't have any other cards. No? Maybe I did. No, I don't. Okay, we will go. I have 2 cards now in opposition. Frederick Sykes. Come on up and be heard, sir.
Good evening, Mr. Redholz, Chair, members of the Planning Commission, members of the city staff, members of the audience. I am Frederick Sykes, 41-year resident, former Human Resources and Planning Commissioner, and also former mayor of this city. You know, I should be accustomed to what I see tonight. And that's that, as usual, that not many are here from my community, and we're getting kicked in the face. This is a loss of equity. I live 7 miles from this, about southeast from this city hall, and that's Woodside Village. That's where most of the density, that's where the first attack of these cell towers are coming from. And Ms. Haim, thank you for your persistent questions. I appreciate that. Thank you. You know, in the 50s and 60s, I lived very poor and densely populated neighborhoods, south central Los Angeles, about 30 miles southwest of West Covina. Every day I lived there, I was breathing asbestos and lead. These minerals were used in automobile brakes, in gasoline, paint, and many other items. These elements used to be everywhere until scientists discovered how they were very hazardous to humans. On many issues, common sense has been purchased away from most of our elected officials in Washington, D.C. So we have very little control over what telecommunication companies want to install in our communities, regardless of our concerns. In my community, all utilities are supposed to be subterranean. And I can show you where Southern California Edison and telecommunication companies have already been given permission to violate that law by our city officials. And there were some pictures that showed some of this defacing of our community. Tonight, you're about to ignore some facts, just as in Washington, D.C. We live in microwave and in electromagnetic waves before this new densification is even started. We do this by our daily use of telephones, microwave ovens, TVs, computers, in all our homes and in our cars, and etc. Now, this is before we add the 5G. 5G will completely deface our city by placing thousands of cell towers on our front lawns, atop our light poles and buildings, and anywhere else telecommunication companies can dream up. Changing the current cell tower distance from our residents creates a density of microwave and electromagnetic waves that has no long-term scientific research about what could happen to us. You are decreasing the value of our property and creating even more health concerns that we already have. You are forcing us to be guinea pigs, lab rats, and the test animals for this 5G experiment. We should be smart and wait to see what happens in China and other locations where they are already forcing people to live in 5G radiation. Please leave the telecommunication towers 100 feet from our homes. Please give our children the same consideration as our California firefighters. Cell towers are not permitted to be installed atop or near our fire stations. We pay for our property, and we should have property rights. We put you guys here to protect us. Please do that. Thank you.
Thank you, Mr. Sykes.
Mr. Chair, if I can just put into the record a quick statement. Due to a line of cases, I need to state into the record that this ordinance was developed without reference to the impact of microwaves on human safety. And the reason for that is there's an express federal law which prohibits the city from considering that. So I just wanted to put that into the record that this ordinance does not take that into consideration. And what we do is ensure that the equipment complies with the federal regulations, and the federal regulation confirms they have drafted the safety standards. Thank you.
Well, I'd like to make a statement. Well, I just want to say thank you for reminding us that we cannot address the RF radiation. However, we can address locations in terms of where, in terms of where we can place it, right? Locations. We can also address the issues of constructions, which means that how big, how small, all that nice stuff regarding new constructions. And what was the last one that we can do?
That's correct. Time, place, and manner. So
time, place, manner, and I forgot the last one already, but somehow it slips my... Oh, I'll come back if I remember.
Okay, Jerry Patras.
Hi, Jerry Patras, West Covina resident. I've been following this and the discussion and the hearings and the placement of the poles and everything. And tonight, it really came clear to me that I need to ask some questions. And part of the reason I'm asking is there is a light pole in the public right-of-way in front of my house. And when I'm hearing about moving poles or adding poles, would I end up with 2 poles in the front of my house? I don't really understand that. I really don't want a box in front of my house. That I find, if I bought the house with the box, that's one thing, but I didn't. And I don't want to have a situation where residents such as myself would end up with 1 or 2 poles within a few feet of each other and a box and my lovely magnolia tree that's the city's, okay? That would wreck my look. I'm in the older neighborhood. We don't have sidewalks. We don't have parkways. We just have that front area that is the right-of-way of the city. if I don't really like the fact that the cell towers are coming into residents. I think the company should really have to work keeping them out of residential areas and into the other areas. I understand there's an issue. If some company comes in and decides to do this, and this light pole is right next to the property line, and he then puts it on my neighbor's, it's still ugly, okay? So we have a little bit of gap between the poles and that lovely magnolia tree that I don't want taken out. For me as a resident, maybe I'm not following this right. Would I have to pay to appeal this if the company just came in to do this? Would I have any say or input into this process as my front lawn gets wrecked? Those are really concerns, because if that happens throughout this residence, it's going to just be ugly. And I really don't want an extra pole in mine or my neighbor's yard. Thank you.
You need to fill out a card, though. Yeah. Okay, go ahead, Angie.
Just real quickly. Starting of Monday of this week, we all heard about weather and conditions, and this being the biggest travel week of the year. So this isn't just a regular meeting. So to Sheena's request, the public may not be out here in numbers, and that's because they're traveling. So yes, it was posted, and yes, it was publicized, but let's consider that we may not have a full house tonight because there's plenty of people on the road flying, trying to get from point A to point B. So you might not have a good representation on many of the items on tonight's agenda. Thank you.
Thank you. Anyone else wish to be heard who hasn't already spoken on this? Okay, I'll go ahead and close the public comment portion. Staff have any comments on what was said at the mic?
Before you close, can I ask Robert a question?
Sure.
Could you come up, please? I just have a few questions regarding the 5G. I mean, I'm not a technical person. However, I like to know what is a 5G. I mean, I know about
question.
1G, 2G, 3G, 4G, but what is a 5G? And do we have any?
No.
So we do not have a 5G currently.
No.
Not one person in West Covina own a 5G phone per se?
Well, they may have an AT&T phone that says 5GE, but that's sort of AT&T's way of moving us in the direction of 5G, but it's not true 5G because there's a standard, a scientific standard for what 5G is, and that phone doesn't meet that standard. So there's no 5G anywhere.
So the 5GE is just marketing scheme?
5G.
I'm just hypothetically, if there's no 5G.
That's your words. I'm not going to, it's my client.
Okay, I'm just going to take it back then. So I'm just saying that you're saying that there's no 5G technology per se. So I just assume, put one to one together, that the 5GE is just a marketing. For me to believe that I got a 5GE, because 5G is a technology.
There may be some software developments that they've added that sort of increase the speed a little bit. I don't know the details of it, so maybe there's a legitimacy there. That's not totally clear to me. I'm not saying there's no 5G anywhere, even in Southern California.
Right.
Verizon has started to deploy certain radios that are fixed, but not in West Covina. We haven't had anything in West Covina that I'm aware of.
So if the new technology, I would assume 5G is somewhat of a new technology, would you say?
Yeah, it's a new platform that's been developed, and there are new chips that Qualcomm is producing, and then there will be new laptops that have it, and radios and cell phones.
So let me ask you this. The 5G, does it work with our existing system that we have right now?
5G, in its true sense, follows a standard that's a protocol that was developed by a body of scientists. It's
Correct.
called 5G NR.
Correct.
right? There's no 5G NR that we're deploying right now. Are we getting ready to deploy it? Absolutely. We are getting ready to deploy it.
Okay, so if the 5G NR, you mentioned that is itself is a new technology.
That's the protocol. That's the scientific protocol.
Okay, so that scientific protocol need a new completely system, work with our existing system right now?
No, you need
It doesn't.
additional infrastructure.
Okay.
You need new radios. You need new sites. There's a range of frequencies that are being used, from very low former television frequencies at 600 megahertz all the way up to what's referred to as millimeter wave frequencies that are, much higher, but they are still below the frequency of visible light.
So the 5G NR does not work in the same frequency as our existing telephone that you and I use today.
It's more complicated than that, but that's pretty fair. Wi-Fi has a kind of higher speed frequency that they use. What this is going to do is combine sets of frequencies together. The whole idea is to create the kind of wave that carries a lot of data, because the volume of data that 5G needs to transmit is substantial. It's substantially higher than what our phones are getting right now.
Okay, so basically it's working on a different wavelength versus
I'm saying
the 3G, 4Gs or whatever.
It's working on a combination of wavelengths, some of which are new and some of which are the same. So they will aggregate. It's called carrier aggregation. They're going to take a bunch of different channels, they're going to put them together, and then out of that radio, out of that antenna, you'll get a much faster signal with a lot more data.
Okay, thank you.
Sure.
I have a question for you, too, since you're up there. In your professional capacity, are you hearing is there a consumer angst or demand for the 5G technology to come forward?
Well, there's a recognition that we're behind the rest of the world in terms of the quality of our wireless communications. There's also an understanding that there's a wide array of technologies that will be available to us under that, from telemedicine to connected cars and all the things that you're hearing about. There's a lot of interconnect. One of the main things about 5G is that it's really about capacity. It's not only how fast you can download a movie, but it's how many devices can actually connect to the network and communicate, because we're moving from human to machine communication to machine communication. So the Internet of Things is going to drive a lot of where things go, and farm equipment and household, equipment and other things will all be communicating. And that takes a network that has the capacity to handle all those devices. So you're looking for wavelengths that carry the kind of data that's necessary for that.
And it appears that just now all the major carriers are advertising a lot, like crazy, about the 5G. I mean, it may not be here, but they're advertising at least to whet the appetite of the consumer.
Well, it's considered a paradigm shift technologically because of the way mobile communications affects how we interact. We've already gone through a partial shift in the sense that, we can talk to each other all the time. We can do work from wherever we are. I mean, you don't have to wait for the newspaper to come out in the morning to find out what's happening, or for the 6 o'clock news. I mean, things have changed already, but we're talking about a new wave of changes, and I think it's going to be spectacular. And I'll say this about residential coverage. One of the problems that we are facing now with residential coverage is that students don't have the ability to do their homework on their laptops at home. And there are school districts that are willing to give them laptops because they know they need to learn how to use those laptops. And the students that are doing well have access to the internet. They have access to be able to grow and learn with those. So our company is being approached by school districts asking for a solution, and the only solution that's going to work is to put infrastructure in residential areas. One of the things about the way things have developed is that residential areas are sort of the last area, right? And it's worked okay because of the kinds of wavelengths and the size of towers and all of that. But to get to this next level, you're not going to be able to do that. And there are many, many residential areas that have been left behind, where kids are being transported to some other location to do their homework. Palm Springs now has started driving buses into residential areas so kids can do homework. I mean, there are solutions out there, but it takes infrastructure to address those issues.
Since you brought the school issues comes up, is it possible for me to see some documents on that regarding helping this school districts and the school districts requesting
I'm
for it?
happy to have you connect to us because we're actually
I'd
having
like to see that.
more school districts come to us and ask us for a solution to this because it's a
Okay.
digital divide question and it's a question about Southern California students.
Okay, thank you.
Sure.
Is it for him to email, or could you
I
provide
can
him his?
communicate with Mr. Anderson. Yeah.
We can forward it on to the planning commissioners. Yes.
Thank you.
Okay.
Thank you, Robert. Thank you very much.
Well, but perhaps I could respond to one of
Please.
the questions that's brought up. You know, there was some discussion about could a pole appear in someone's front yard. I think historically the answer to that was yes. And we're not talking about ancient history. We're talking about as late as earlier this year. It could have just appeared there, and there would have been no notice because that's how the code is set up. The code isn't set up to review wireless facilities in the right of way. Those were just sort of exempt, and they went through, and Joanne showed some pictures of those. So no one ever. There was no notification. They just got a permit and put them in. So this code is trying to get to a place where we have some kind of reassurance of what can or can't be put in, and that's Barron talked about that earlier. The idea that in the guidelines right now is if you do these things, we can do it ministerially without notification, but those wouldn't be, you couldn't put a second pole up. You'd have to replace the pole that was there or put it on the pole that's there, and it has to be within 3 feet of that. The other thing is that any boxes have to be below grade. If it doesn't meet either one of those things, then it does require the major and notification, the major wireless facility, and the notification and the process. So the answer would be yes, and if they meet the guidelines, so that's why it's very important to set the guidelines up well. If they meet the guidelines, there wouldn't be any notification. But if they didn't meet the guidelines, and new poles that were just appearing that weren't replacing a pole wouldn't meet the guidelines either, I don't believe. So that's kind of a general answer to that question. I think that's...
Actually, I had a question adding to what you just made a statement earlier. So you're saying that if someone has a property of 100 foot or 200 feet, potentially, since it's such a new technology, and I believe Lord Johnson, who's sitting up there, had raised this question and asked this question before, you can potentially, I believe City Attorney was there as well, you can potentially, with the existing pole, 3 feet away, you can have one with one carrier.
3 feet away to replace the one.
To replace the one. And then you can potentially add a few more with different carriers throughout that whole string, just assuming that since it's a new technology, they might, different carriers has their different little requirements. I'm just assuming. So potentially, if you have 100 foot of frontage in your house, if 20 or 25 foot in each, each location. So I'm not saying that T-Mobile or Crown Castle is going to put all 4 of them at the same time, but potentially, like let's say Verizon can put one, AT&T can put one, Crown Castle can potentially have one.
This is where your control over aesthetics comes in. You have control over aesthetics, and putting that many poles close together sounds really ugly.
Right. So prior to what we're working on today, that's why it's important to work on today and have all these discussions basically ironed down so that we can avoid these type of issues in, hopefully, I'm not sure how yet, but we'll have this discussion. So what you're saying to me is that what Lord Johnson was afraid of in terms of his frontage, most people don't have 100-foot frontage in their house. So I'm just saying that if you have a long frontage in your house, you can potentially, in the past, have more than a few.
I want to be clear.
Yeah.
The administrative portion here is putting on an existing utility pole. So there has to be an existing street light. So there's a pole already there. If they're coming in with a brand new pole, That's not administrative. That's coming to you for a CUP, and you have all the discretion under a CUP to say no, maybe, or yes with these conditions. But there has to be an existing pole there already for it to be administrative.
Okay, so the administrative is existing pole with 3 feet away, potentially.
Within 3 feet, yes.
And the 3 feet is only if we're requiring them to replace the pole. For example, if it doesn't support the equipment, they have to replace it, so it will support the equipment. And then they can move it, but only up to 3 feet. If they go beyond 3 feet, again, it's outside the standards and has to come to you for a CUP.
Just to clarify, the 3 feet that Barron was mentioning, that's in the current design guidelines. In the proposed ordinance says that wireless facilities, in order for it to be considered a minor wireless facility application for basically staff approval, it has to be at least 250 feet away from another facility. Otherwise, if it's closer than 250 feet away from another facility, it would trigger a CUP, so it has to go to Planning Commission. So that's the way the draft ordinance is written.
Okay, and also regarding the new pole, that potentially if they need a new pole, you're saying, I just pick up something that you just mentioned earlier, that potentially is because their equipment doesn't fit in their existing pole. Potentially this particular pole can balloon up to 16 inches with all the equipment that they like to put in there. Is that the assumptions? I'm assuming that if
That is correct. You're correct in that assumption.
So, okay, so the existing pole with the smaller lamp posts and all that stuff, if it doesn't fit their equipment, they can actually increase it up to 16 inches with a lot more equipments that they can put in there, per se.
That's the 16 inches is also in the current design guidelines. It's not in the draft ordinance. It's in the current design guidelines.
Okay, and we're talking about the design guideline, not tonight. We can potentially...
Talking about the design guidelines tonight, the Planning Commission's already adopted those design guidelines. They're in place right now. They were adopted in April. But the idea would be we would bring those back for further clarification and review after the adoption of the ordinance.
I see.
So the ordinance doesn't specify what it's supposed to look like as far as the details are concerned. That's what the Planning Commission decided in the study session. They wanted design guidelines to basically determine how the pole is going to look like, or how the small wireless facility, what aesthetic is acceptable to the city. So that's going to be determined by the design guidelines, which is not part of the discussion tonight.
We can definitely do some study on the size of poles and measure and bring that back to you when we bring that back, so that so that your concern is addressed if that in fact is a lot larger than a normal pole.
Okay, and then also another question is regarding 100 feet or 250 feet in this case away from certain telecommunication. What is other cities are doing since everyone is adapting these new type of facilities? Do we know, or is this something that we come up with and we don't know what other cities are doing? I mean, since it's new, obviously I don't know. So I was wondering if staff knows.
Well, most cities are doing the same thing we're doing right now. So, I mean, it's kind of it's kind of the same thing as we're going to talk about the ADUs. Everybody's doing it right now, so you can't wait for other cities because you got to have something in place. But it's a good question.
It varies. Some cities have it at 250 feet as well, and some cities have it at 100 feet. So it varies throughout.
Yeah, I like to know what other cities are doing.
And also to point out, I checked the cities immediately surrounding West Covina, and from what I found in their code and also through them, they don't have an adopted ordinance yet that specifies aesthetics.
Robert, can you answer that or add something to that? You want to come up forward, please? I'd like to hear it.
City of Costa Mesa is looking at 500 feet. But what they're saying is it's 500 feet from your facility. So if there's a Verizon facility that is 100 feet around the corner, serving the same, whatever, that's not the separation that they're looking at. They are looking at what is the average propagation for a small cell, and so how close do they think you need to be to build your network, not how close are you to somebody else's facility. So it is another way to think about it. In this case, I think the city is saying 250 feet from any facility, and we would probably have a problem with that, which would mean we would be coming to you to talk about, why it's important.
So hold on. So you're saying 250 is a problem for Crown Castle per se?
250 from other people's facilities. So one of the things that we're not
Do you want it closer?
Well, one of the things that we are not talking about is co-location, and one of the things that Crown Castle does is provide co-location. So in terms of the design of the facility, whatever it takes to combine multiple radios from multiple carriers, we do that. We have the ability to do that. So if you don't want AT&T next to Verizon, next to Sprint, next to T-Mobile, or next to Dish, or whoever else is in here, we have the ability to combine that, and under the code, there is a preference. It's not really specified what that means, but there's a preference for co-location.
So when you co-locate this particular item, if it's the maximum height of lampposts is that some of them is 20, 30 feet or so?
We can co-locate. It doesn't have to be 50, 100 feet. We can co-locate it 25, 30, 35 feet without any problem.
Well, I understand that. Like if this is a pole, how far apart in terms of height-wise do you need to put?
That separation is no longer relevant.
So you can actually stack one on top of each other.
There were issues in early macros where there needed to be separation. That separation is no longer relevant. We can put radios right next to each other. We can have radios from different carriers going into the same exact antenna, and we do.
I guess that brings me to the other questions regarding the fact that Costa Mesa said from your own facility, which let's say T-Mobile has one that's 500 square. Hypothetically, we're talking about Costa Mesa. So if Crown Castle has one, another 500 feet, you can have another one. Let's say AT&T comes by and say, well, this area, we need one in front of this person's house too. Potentially, they can apply for another one. Let's just say pick up a Verizon, and then another 500 feet from there, they can also put another one at their choice. Is that how I understand it correctly?
Yes, you could have staggered networks. That's correct.
Got you. So what Mayor Johnson in the past, not anymore, sorry. So Council Mayor Johnson had discussions about his front house can potentially have more than one tower. It's a potential. He might encounter that issue as well.
I think at a 250-foot separation, that situation would be highly unusual.
In our case, right now we had 250.
Right.
Oh, correct.
Exactly.
Correct. Okay.
Right.
All right. Thank you.
Okay. Any other commissioners have any questions of staff? Anyone dare have a question of staff?
I think I do.
Oh, go ahead, Commissioner Jaquez.
In the, let's see, let me get the correct section here. In the WTFP application submittal requirements, there is the section on the RF compliance report, and it states that the applicant has to have an RF report that must be prepared and certified by an RF engineer acceptable to the city. And the RF report must include actual frequency and power levels in watts for all existing and proposed antennas at the site, and exhibits that show the location and orientation of all transmitting antennas and the boundaries of areas with RF exposures in excess of the uncontrolled general population limit as determined by the FCC. So with this RF exposure report that's submitted by the applicant with their RF engineer, just wondering, how is, on the city side of this, how is our check of that done? And, we're basically taking a report that's submitted by this RF engineer, and maybe the gentleman from Crown Castle could possibly answer this as well. But is this an area of expertise that is covered by the state licensing board? Is this a licensed electrical engineer in California that's submitting this? What is the city's check on that to see that their report that they're submitting confirms that it follows all the FCC guidelines on RF exposure?
So this comes back to legally we don't enforce RF compliance with federal standards, but what we're requiring here is them to certify that they are in compliance with federal requirements. And then it becomes a dispute between any person out there who wants to fight with the carrier over the issue. So we're doing what we can in getting them to put in the paperwork and the certification saying we comply, because we're not going to let them come in unless they commit to the fact. A license, specifically an RF engineer, licensed engineer, certifying this report, just like an architect or any other type of engineer. So they put that report, we keep it on file, and if a homeowner has an issue, they'll go to the courts against the carrier. That's not the city's liability.
Hold on, I'm sorry. Could you repeat toward the end? It's a good question, by the way, Commissioner.
Yes. So as I've indicated before, we're preempted from enforcing any regulation related to RF on human safety. But what we're doing here is what we can do is have them commit that they are complying with the federal regulations, because the feds are the ones who can enforce and set the standards. So we're saying you can't go through this administrative process unless you have a licensed RF engineer certify that you're in compliance with the federal regulations. That's what we can do, and that is what we're doing in this situation.
But we can only request for a report, but then you're saying toward the end, I didn't catch you earlier, you're saying that if it doesn't comply or comply, then it's up to the owners to challenge that with the company? I thought that's what I heard. I'm not sure. Can you clarify that?
That is correct, because the city is not in a position, doesn't have the expertise to really even, if they want to commit fraud, that's on the carrier. Or if an RF engineer is going to lie through his teeth about it, it's not the city's, we don't have authority to enforce that, if that makes sense. So yes, an individual can sue the carrier using, it's a public record, that report.
I see. So we're kind of forcing the resident to some extent to allow to put this small cell sites on their property or in front of their property, but when there's an issue, then it's up to the owners to challenge them. Is that what we're trying, is that what you're, is that?
I wouldn't state it that we're forcing.
Okay, forcing is a strong word. Let's just say how can you say it?
We're imposing the requirements and the requirements that we're allowed to require to the most extent that we can, including them having a licensed RF engineer certify RF compliance. That we can do that. What we don't have authority to do is to look at this report and say this is not true, or to double check it. We don't have authority to do that. But we were creating a public record now that the public can look at and double check. They can report to the FCC. Those are things that we're enabling the public to do by having this document.
Now, I was the one who brought up the terminology of a licensed engineer, and so now I hear you repeating that when the language in the draft code here reads, RF is prepared and certified by an RF engineer acceptable to the city. And I guess my question is, because I'm not really familiar with the area of expertise of RF engineers. I myself am a licensed civil engineer. I'm licensed by the state of California, as would be any other civil or electrical or mechanical engineer, or chemical engineers. There are various other licenses that the state license board issues, but I'm not sure if that's covered but in an area of expertise for an RF engineer. And maybe is that something that falls underneath the purview of the electrical engineering licensing? And I don't know if RF engineers are a subdiscipline of electrical engineers. But nonetheless, it doesn't say, it does say an RF engineer acceptable to the city. It doesn't say a licensed RF engineer. So.
Yeah, thank you for that clarification. I'd have to defer to to Robert on that one because it is
Maybe
more of a
knows,
technical
if he could
consulting
answer
question.
That. Yeah, I'd be curious to know.
But also at the same time, we can actually put something verbiage in there saying that it has to be a state licensed engineer, RF engineer.
Well, that's my question.
Is that?
That's my question. If it's a license.
I mean, is there such a? I mean, obviously, if they're an engineer, there must be a state license.
Yeah, I don't have an answer. I know that at the last council meeting, they did bring someone who represented as an RF engineer. I think it was electrical engineering. It's an electrical engineer then.
Okay, so it's a subdiscipline of electrical engineering. Okay, and therefore they would expect him to be a licensed engineer. Okay, I'll hold on to that for comment later.
Actually, I want to add on to that a little bit. California is very strict in terms of their licensing board and their license to some extent. It's just like their board for their dentistry or pharmaceutical or doctors. It's very intense in terms of how they tested it and how they get licensed. I guess my question is there any way that we can add on to, it basically has to be a state license,
Well,
California
that's what
state
I was going to
license?
bring up, but I think we'll have a moment to discuss that once we're done with the staff questions.
Speaking of that, any other questions for staff at this point? Staff wish to add any other comments? All right.
I actually want, I have a question regarding the staff is that I like to see regarding the 200 feet proposal, I like to see what other cities are doing. I know it's new, it's been a year or two. Yes, the 250 feet, and I like to see what other cities are doing in terms of that portion. The RF compliance, I also wanted to see if it's possible in terms of there's a fee imposed if it's not complied. I don't know who, I mean, obviously, the city can actually impose a fee if the RF is not complied. Or how do we know what is compliant and what is not?
So the compliance report is a condition of the application. If they don't submit it, it's an incomplete application. But again, it comes back to most cities don't have in-house electrical engineering expertise when it comes to radio frequency. That is enforced and regulated by the FCC. So while we can require them to certify they're in compliance, I think we're on very shaky ground to start analyzing that report ourselves, because we don't have that expertise. So if there's a concern there, the recommendation I would have would be to refer it to the FCC.
We're stating the fact that we're trying to read the report, which we should. Someone in the city needs to know how the report is done, or we hire someone that actually is an expert in this area. Like, just assuming that if they're not in compliance, the questions come in is there like a fee schedule set up so that they can get to comply? Hypothetically, let's say if they're not in compliance, it can go for years without us knowing. Or
No, because if they don't they submit the report when they apply, when they submit their application for the permit. So if it's not included, then it's incomplete, and this process is stopped.
I see. So if they make adjustments to that particular equipment, then they don't need to resubmit their report anymore. Things gets upgraded every day. I mean, obviously the the equipment that they put in there 10, 20 years ago is not going to stay 10, 20 years old. If they were to upgrade it, we had no requests for these things?
The way the ordinance is written, they have to submit an RF report prior with the application, and also once it's installed, they also have to submit a report to verify that basically it was installed correctly and it complies with the RF standards as installed.
I'd also like to add that the permit runs for 10 years, after which they need to essentially reapply.
Grade, there's no report need to be submitted and what have you. So potentially for 10 years, they can do changes added every other 6 months or so, and we have no idea whether that's compliance or not.
If the upgrade requires structures to be placed in the public right-of-way.
Well, a lot of times the antenna do not require structural.
If it requires an encroachment permit or anything that a new box, new radios, new antennas, then it would require an administrative review at the lease, and that is also required as part of the application process.
I guess that leads to another question: is that how many of this upgrades have we done? Have they done within our city? None?
In the past, it didn't require planning review, so the planning division doesn't have any records of it.
Yeah, part of the problem under the existing code is there is no such requirement, which is why we're trying to get in place this ordinance so that we can have those kinds of standards put in. And going back to the RF question, we have to think about what are we trying to accomplish there, because the RF radio frequencies are invisible, so it's not really an aesthetic question, which is the authority this commission has to regulate.
I see your point in terms of we can't see it, we can't touch it, we can't feel it. It doesn't, there's no aesthetics to it. But at the same time, I like to know whether they're in compliance or not every time they do an upgrade. I mean, obviously, I cannot believe that with the last 20 years that they put a machine up and they upgrade it every so many months or years, and we don't know what's up there. I mean, I don't know if we don't know or there's a report out there, we just need to get one. Is that too hard to, well, actually, we can actually have a discussion. Is it too hard to ask just for them to submit it if there's an upgrade? Just hypothetically. Now that we're working on this particular, I know in the past we don't have anything. I cannot believe, maybe he should answer the questions. I mean, if the equipment been approved 20 years ago, is it the same equipment's been sitting there for the last 20 years, or have they been upgrading every so many months to date, and we had documentation that was 20 years ago, but nothing current as up to date? I don't really, honestly, I don't know how to read the report. Hold on for 1 sec. I don't know how to read the report, but I like that for the publics to at least come and see it, say, hey, look, for the last 20 years, this is what's been done in that area, if they wanted to.
My understanding would be that that's what the federal government does. Now, also, the federal government licenses them through the FCC. They have to report to the FCC on if they're doing things legally. That's the FCC's job. Now, there are lots of other uses. Let's just talk in a general sense. We have service stations all over the city that upgrade their facilities all the time, and there's a health aspect to that. But the city doesn't go try to check that because there's a state agency, there's federal agencies that review that type of thing. Same thing with ABC licenses. So we have to understand, I believe you do understand, that you're looking at most of the planning department here right now. Everybody's here but one of us. So the city does not have the resources to check up ad nauseum on every type of issue that there is in the city that could come up. We have to rely on other state agencies to address these issues. Well, the other thing that I would tell you, the story about...
Hold on. You might have answered your own questions already. My question already. You're basically saying that if the FCC is checking on them, then that's fine. We'll just direct our residents, go there and take a look at it, and we're done. So basically, help us look to see if the FCC is checking into this, or the state is doing it, like the ABC licensing. And if they
It
are...
wouldn't be the state, it would be FCC.
Okay, so if they are, we just direct them to staff or to residents, say, hey, if you want to look, these are the upgrades, these are the reports, go. And if they don't have it, then maybe we should look into that, say, hey, look, just give us a report every time you upgrade. That's it. Whether they want to read it or not, that's indifference.
Well, you're right.
I wouldn't know how to read that report anyway, but I like for whoever's being affected to actually get a chance to take a look at it to see what's with that. Which
And that's all doable, and maybe
Right.
Robert has a comment on that, because I think he's the only one that knows really what he's talking about in this regard. But the other thing that I just want you to understand is that RF engineers like to work for a company that will pay them well and that will keep them employed. So who is that? So a couple of years ago, we decided we were going to try to hire an RF engineer to review one of our projects that was submitted to the city. We went out for an RFP twice, and we didn't get any proposals. No one submitted. The only one that came to us did work for the cell companies. So this is not a process that's probably going to be very helpful for us to go down
it's
that
not
road.
so much of helpful, Jeff. It's basically we have documentation. That's all.
No, you're right. I'm not talking
we
about the
don't need to understand it. As long as they do an upgrade, put it in the file and say, here it
I'm
is, and
agreeing
that's
with you.
it.
I'm agreeing
So if
with you
someone
there.
comes along and say, hey, I want to look at it, then they can look at it and try to decipher what it is that they're looking at. Obviously, I don't really know, and I wouldn't be able to read that report, but obviously someone out of 120,000 in our city, someone must be an expert in this area that they would like to take a look at it. That's actually, it's just an option for the residents to look at. Now, like I said, if the FCC has that report done, required by the you might know, by the builders, then we don't really have anything to request for. We just basically say, hey, look, if you want this information, here you go. Go take a look.
Anything else? I don't know if the report would be trusted anyway. I think the report would be questioned ad nauseum myself, no matter what it said. So where are we at now? I'm completely...
Well, we've had the hearing, and now it's ready for deliberation by the Planning Commission to determine if you want to go forward with the ordinance, if there's things that you might want to modify, still go forward. If you'd like us to research some issue back when we're completed with
So does this have to be adopted tonight, or can we?
No, it doesn't have to be
Okay,
adopted.
so there's no...
There is no bomb that's going to go off. I
Right.
shouldn't use that terminology. There's no problem that's going to happen. We're not going to all be, the water's not going to come down on our heads tonight if we don't do it. But
Are you sure?
Well, I'm not totally sure, but I am aware that we do have other applicants besides Mr. Jysted who are itching and will probably be submitting soon. So the longer we don't have a code, the more we have to go through the process that we've sort of set up quickly. So that's the one thing I would say. It's not like we have forever, but we don't have to do anything tonight if there's further information that you would like to have us research.
Okay, so what is the pleasure of the commission? Do we want to have some questions answered and come back in another form, in a study session form, or do we want to move forward and hammer this out and get something adopted tonight, or,
I do have a lot of, I'm sorry.
No, go ahead.
Chair, I do have a lot of questions that's not answered in terms of just a few of the items right here. Another questions that not questions, but one of the residents had raised a good point is that I was supposed to be out of town this weekend, but I decided to stay behind because there's so many procedures. Taking that in consideration, Thanksgiving is Thursday, 2 days from now. So a lot of people, it's the busiest travel date tomorrow. So most people, if they plan ahead of time, probably left to be with their families or what have you. And I like an opportunity to actually get some more information from staff, if ideal, and also to see if in the future, within a week or two, when Thanksgiving is over, perhaps we can actually have another study discussions if more of hopefully residents
Then
here.
you're into Christmas at that point, so we're really looking at next year.
Okay.
Please keep in
So-
mind that the city council is going to ultimately make the decision. You guys are
Correct.
just providing a recommendation anyway, so it's not like the final decision would be tonight.
Yeah.
Any way you slice it.
But we need the residents' input, and we also need to have questions answered. In the meantime, we could do that.
Are you asking for a study session then?
Yes.
Okay.
Yes, thanks.
Any
Just
other-
to get some answers clarified and some more of the item or bullet points, iron out.
I don't disagree with you. I would like to have this presentation in front of more people, in front of more residents other than Angie and Fred and Jerry. More people. I mean, you guys are here all the time. I'd like to see some other people too, hear from them. Right? No, you represent yourself right now, Angie, to be honest with you. You're representing yourself. Exactly, yeah. Yes, Commissioner Kennedy.
I have a question for the gentleman here. So with this 5G, when are we going to go to 6G? When are we going to go to 7G? When are we going to go to 8G? So at what point is this just temporary? Is in 5 years, what are we going to do? Those are because technology is always moving all the time. So I'm with Sheena here. I would like a study session. I really would. So I know that we're going to need to ask more questions. Only 4 people in the crowd ain't going to cut it. So that's my opinion.
Go ahead.
So do we move?
You want to make a motion?
I'll make a
But
motion.
before you make a motion,
Okay.
let's make sure we're clear on what you want us to bring back, because I appreciate that. I wrote down a couple things. One was the base of the light pole. We can do some research on that, although that's not necessarily part of the code, but we can still do that, get that information out. Then the only other thing that I heard discussed was sort of more information on how other cities are dealing with separation of facilities. There was a mention of what Costa Mesa may be doing, and we can certainly find that out. And then I always also like to be clear that clearly we're not going to be able to find out what every single city in California is doing. I usually would suggest is we research about 10 cities around us, and we find out what they're doing, and bring that back to you. So that would be the 2 things that I can see. Is there anything else that you would like us to research that we've discussed here?
Well, Commissioner Holtz, he hasn't said a word. Go ahead, Don.
Let me understand. Back in the July, we had a study session, and we gave you items to come back to us with that we had concerns with or wanted direction on. Are we still going to accept those things in addition to what we're going to do in the next study session?
So what you would probably be doing is modifying what direction you gave us on July 23rd.
Okay. So those are not for naught.
Well, they're not necessarily for naught, because you may decide that what we have before you, we could come back to the study session in January, and what's before you, you decide, hey, this is fine, we're going to deal with this.
Okay.
So we wouldn't change the code, and if we do a study session, it's not a public hearing. So you couldn't make a decision.
Right.
That may be one direction. Do you want the study session, or do you want a public hearing that you can make a decision that night? That may be a question that you want to give us direction on, because that's a big deal, right? If you do a study session, you have to have a public heering then before you can send it on to council. So you have at least 2 meetings.
So this public hearing could be continued then?
If we had a public hearing, we could. I doubt if we had a public hearing, we could make a decision in the same night.
So a study session
Right.
would be ideal then.
Can I let him finish my?
You could do it either way.
I know you can do it, but I doubt that would happen. If you have a hearing session and make a decision the same night, I don't see that happening. Thank you.
So the options are, we could continue this public hearing and get answers to these questions. There aren't that many questions. We could get answers to those questions. It presumably would be at a more opportune time for the public to be here. And we could get those questions answered and at that point make a decision as part of a public hearing. We can't make a decision at a study session. That would require another public hearing. And I fear that this could just go on forever. So I think at some point we have to put a bow on it. So what is the, and I'm good with having a continuation of this, giving staff the opportunity to answer the questions, and then coming back, after the holidays, presumably, and making a decision.
I'd like to ask a further question, if I may. Yes. How many people do you have to have here before you'll feel comfortable that you have enough input from the applicants or the city?
Well, that's a question for the planning commission.
No, I know, that's what I'm saying. I mean, how many people? 15, 20, 30? It's always the same people that show up, usually.
I think it's not about so much
Can
of the.
I get an answer to my question, please?
How many do I need?
No, I'm just saying, what's the council think? I mean, the commissioners think. How many do you need to have here? Because it's always the same people. But I mean, you feel more comfortable if you have 20 people here, 30 people here, 10 people.
The only thing, what I'm doing, I mean, I'm just reacting to a concern that was brought up by a resident. Okay, and the point is well taken. This is not the most ideal week. Right. To have, this is a pretty big decision, and I think it's, and you're right. I mean, there's a crew that comes out, and that's fine, but maybe we could get a few more. And I guarantee you this will not be a filled chamber.
I know that.
For that. Only Tony Wu can fill the chamber. We know that. So, okay. I mean, there is no magic number. Okay. But to me, tonight is not the ideal night because it's, the holidays.
It's just about affording the opportunity.
Yeah, it's about, exactly. And I'll tell you what, we've given the public opportunities in the past. In the, hundreds of years I've been on this commission, we give them opportunity. But again, it's up to them to grasp that opportunity and choose to show up and participate. We can only do so much. Right? I mean, we can't go door to door with a rope and drag them in here. I mean, we can't. They either have a concern or an interest or a desire to be heard on this, or they don't. I understand what you're saying, Commissioner Holtz. I think we might get a few more. Maybe you folks can, go, get out your Rolodex. Remember that? Get out your Rolodex and go get some people in here. I don't know. But bottom line is, if they do show up, we'll hear them. If they don't show up, it's to their peril, potentially. So, I mean, I'm all...
So the next meeting, how many show up, that's the final. We're not going to say we need another public hearing. Okay.
Well, we won't, and it takes 3 votes to do anything. Right. Minimum. So...
I guess what the chairman is trying to say is that if we haven't finished and satisfied our discussions, we can continue this further until we iron down what it is that we want, per se, for the new code.
So, just continuing on with this is fine. That way, we could probably make a decision at the end of it.
I'm going to go ahead and make a motion that we continue this public hearing to what, a date uncertain?
No.
Or a date?
We would want to do it to a date certain. And
okay.
I'm going to suggest January 28th.
That's my motion. Is there a second to continue this till January 20th? It's nobody's holiday.
Second.
We have a second? Did you second?
I'll second it.
Oh, Holt seconded it?
Greg seconded it.
Greg seconded it.
Yeah.
I seconded it.
All right. All right, we have a motion and a second. Does everybody in the audience understand this? Okay. Motion and a second to continue this public hearing on this ordinance till January 28th. Okay? May we have a roll call? I want this on the record. Roll call.
Hold on. I'm sorry. Can we add a few items that perhaps maybe staff can find out also prior to coming?
Please. Yes.
Now's the time.
Yes, there you go. And one of the items is regarding distance. I like to see what other cities are doing.
No, that's on the list already. The separation is already on the list.
The other one is regarding Commissioner Hoquez's questions or on licensing to see if this is a California state licensing. That's interesting to know. And then regarding the FCCs and the, what do you call those things? The updates and reports to see if they have one. I don't know, maybe perhaps you can just ask them to see if they have it. Robert?
I'm sorry, who's they?
I'm sorry. we'll check it out to see if the FCC has some type of records that they mandated or asked, or state. It doesn't matter which agency has it. It's not really, as long as someone has it. I just wanted to know if the federal's doing it, the state's doing it, or the city is doing it. Obviously, the city is not, our city's not doing it. So that's the other thing. And then, anything else?
That's up to you.
And then also regarding the design review, will we be talking about that as well in terms of, so we can tie it up together?
Well, what I would suggest there is that it's in your document. It's what is it,
Yes.
attachment number 3. Oh, no, it's attached to attachment number 3. It's one of the exhibits on attachment number 2.
I mean, this is out of line and out of question. Can you guys number these pages so that at least when we're looking at it, we can say go to page 15?
We would love to do that. No, the answer to that, believe it or not, is no, because it's a program that produces this document. It doesn't allow for page numbering. Shocking, I know. We don't like it either, but it is what it is.
So,
One of the reasons it is that way, just so you understand, is this program was set up for electronic production. So this program will
but it's a
allow
PDF
us,
file. You can actually insert a page, no?
you can talk to our clerical about that. They've been through this already. We've been doing this for a year, so they've tried all kinds of different things. And if you look at council reports, you'll see the same thing.
Is there anything else you want to add to staff's burden before this?
No, that's
Next.
really...
It's not a burden. It's
I
a
know,
joy.
I know. I'm just trying to lighten the air. That's all I'm trying to do here.
Sorry, let me just point out on the ordinance itself, other than, for instance, attachment 1, there is a page number on the top left-hand side.
Oh, true.
Yeah, on the attachment there is.
Oh, I guess the last item is that regarding the, the last item is regarding the design guidelines, to see if we can have a discussions about that particular.
I did the same thing. We can certainly have that discussion. I think that we may not want to make a final choice on that until council's adopted the code. So in other words, we can have that discussion, but after the planning commission sends something to council and council adopts it, it'll come back to you guys.
But when you're sending a documents to council, this design guideline is what they're going to see.
It accompanies it, correct.
So can we have a discussion about the design guidelines so we can send a complete package of what we
Yes.
want to them?
I'm saying yes. I'm just pointing out that it's going to
Yes.
come back to you afterwards again.
Correct.
So yes, we had it tonight. We did have a discussion on it. That's where the 16-inch thing came from. So yes, we can, just like we did tonight, we can have that discussion at the next hearing.
Anybody remember the motion? Okay. There is a motion on the floor in a second, correct?
I think you had a roll call ready to go.
We had a roll call ready to go. Okay.
I'm sorry, for the record, you've reopened the public hearing and are continuing the public hearing to a
Yes.
date certain. Okay.
Yes, exactly. Yep. Go ahead.
Commissioner Holtz. Aye. Commissioner Hing.
Aye.
Commissioner Kennedy.
Aye.
Commissioner Jaquez.
Aye.
Chairman Redholz.
Aye. So that motion, such as it is, passes 5-0, and we will take this up again January 28th. Okay, so get your tickets early. It'll sell out quick. Does anyone need a break for 5 minutes? Okay, let's take a 5-minute break. If we can get back to order, such as it is. All right, now that we're all refreshed and invigorated, we shall move on to item number 3, which is a code amendment number 19-02. The applicant is the City of West Covina, citywide, and the request is proposed code amendment consists of amendments to Chapter 26 zoning of the West Covina Municipal Code to revise standards in the zoning section of the code for residential agriculture and single-family residential zones, and to consider eliminating standards for accessory habitable structures. So we will now hear the staff report, which will be presented by whom?
That'll be presented by myself.
All right.
You can call me the Community Development Director, or you can call me the Planning Director.
Just call you Jeff.
Or you can just call me Jeff.
There
Yeah,
we go.
any one of those will work. So this is Code Amendment number 1902. It is for R1 standards and AHQs. The proposed Code Amendment would revise standards in the residential, agricultural, and the single-family zones and eliminate the standards we have for accessory habitable structures. I keep using that term. It's actually accessible habitable quarters, which is AHQs. That's the technical term in our code. The City Council initiated this Code Amendment on April 4th after the processing of Code Amendment number 1802 for accessory dwelling standards, ADUs. The Planning Commission held a study session on July 23rd, 2019, where they gave us direction on how to proceed. This is exempt under the CEQA. So basically there's three sections of this. First is rear setback, second is accessory habitable quarters, and the third is vehicular backup space. So rear setbacks. The city currently has a 25-foot rear setback for one-story and two-story structures in the R1 and the RA zones. The code does allow an exception to this for one-story structures that encroach no more than 40% into the rear yard, but have a minimum setback of 5 feet. So basically it allows it up to 5 feet. Direction at the study session was to increase that minimum setback to 15 feet. For most lots in the city, it's not likely that a room addition will be built at 5 feet. The issue that has been coming over the past few years is that a lot of ADUs are being constructed at 5 feet, and there was a concern that was impacting privacy on neighboring yards. Based on the legislative acts that the state has done, I've listed out the alphabet soup of numbers there. We have to comply with those. One of the standards is you can't require setbacks more than as close as 4 feet. There's some variety there, but 4 feet seems to be the general requirement for setbacks. So based on changes required by the state at this time, staff would recommend not modifying the rear yard setback. The original concept was to provide for privacy in rear yard areas. However, the state has eliminated the city's ability to provide such protection of privacy. So we're suggesting not changing that, just leaving that alone. We always have the ability to deal with that as part of the ADU code amendment that we're going to be talking about in the next few minutes. So the code amendment has been prepared as directed by the Planning Commission with the 15-foot, but we're suggesting that you remove it, and we would ask you to do so under the motion. That's just basically following through because we're following your direction in preparing the ordinance, and we didn't want to take any authority on ourselves when you gave us the authority to move forward in that fashion. Accessory habitable quarters, which we formerly called guest houses. Just a few years ago, we changed the name of that. You know, it's been an interesting ride over the past few years. There was a time when guest houses were given out like water, and we were fought second units, what we call ADUs now, tooth and nail. And we have hundreds of guest houses in the city, and we have very few second units. Over the years, we had some issues that came up, and so it sort of changed, and with the state, made it very impossible to require a discretionary permit for ADUs. So we started requiring a few years ago, the city started requiring a discretionary review for AHQs. And because that's happened, last year we had 15 ADUs applications submitted. We had no AHQs. We've only had one in the last three or 4 years. So AHQs are not something that people are interested in anymore. They require an AUP, they require a garage. And ADUs are much simpler. They don't require any kind of notification. They don't require a garage in most circumstances. So the draft code amendment incorporates the deletion of the standards for the allowance of AHQs. The definition and the references have been left in the code as there are many guest houses that were constructed over the years and some AHQs, and those things are still in existence, and there's covenants, and we want future staff and future homeowners to understand what those were. So we leave them in the code for definition's sake, but the standards have been removed. So that's what the code does there. Lastly, vehicular backup space. Currently, the municipal code requires a 22-foot backup space for garages that are in the side yard and a 25-foot backup for garages in the front yard, and then an overall minimum of at least 22 foot for a driveway behind the property line. However, the code does not have any regulations about the distance between garage doors and another structure on the same lot. So picture a garage in the very back of a lot, and now you have a house that's sort of in the middle of the lot, and now they want to do an addition, and that addition may actually block complete access to the garage. So this has been something that the staff has had a policy on for years, and we've always been able to work those things through, but we think it makes more sense to codify that. We talked to the Planning Commission about that on July 23rd, and so the draft code amendment includes a requirement for a 25-foot backup space from the opening of the garage door to the nearest structure. So staff is recommending that the Planning Commission adopt a resolution recommending Code Amendment 1902 to the City Council. That concludes my staff report.
Any questions of staff on this report? Commissioner Hing. Yes?
Well, I'm just thinking, Jeff, can you clarify regarding the 25-foot back space? I thought when you back out the car, you just back out the car. So what are you, you need 25 feet of
Space
backing?
to back the car. So keep in mind that most cars are about 20 feet long, 18, more like 16 to 18 feet long, but you have to be able to maneuver a car. So, you have to sort of picture the scenario that I'm describing. Not every house is going to have an issue. If your garage is on the front of the house and it's facing the street, there's never going to be an issue.
Okay.
These are situations where the garage is in the backyard, and you have to go by the house to get to the garage. And then a lot of times in those circumstances, people want to do an addition in their backyard. And we've had people come in and want to put an addition as close as 10 feet to the garage door, which you can't get a car in that. If it's 10 feet from the garage door, a car can't maneuver to that capability. So the 25-foot would ensure that there was access to the garage and no structures could be built in that access to the garage.
I guess I'm still not clear in terms of the 25 feet. You're expecting the cars to go in and is then backing backward. You're expecting the car to turn around, and that turnaround area is 25 feet?
No, they're not turning around. They're just backing out, simply accessing the garage. It has nothing to do with turning around. They would back, in those scenarios, I assume they back out the driveway, or they have another pad where they turn around on the pad, but that would be up to the property owner if they want to be able to turn around or back out.
So where does the 25 feet start and end?
25 feet would be measured from the garage door back, 25 feet.
To the sidewalk?
No, you see, you're still picturing the front. We're talking about garages that are in the back of the lot.
Right.
So, in a situation like that, it'd be, let's say, 125 feet from the garage door to the street. But there's a house between them. And a lot of times that house, we have, I'm aware of neighborhoods in West Covina that have a 10-foot driveway. So there's a 10-foot opening to get to the
garage.
To the garage. They need 25 feet to be able to come out the driveway and then maneuver down that driveway backwards. Has nothing to do with turning around. That would be up to them if they wanted to turn around.
So where does the 25 feet start? This way or the long way?
Long way, depth, away from the garage door.
I see. Okay, thanks.
Any other questions?
I make a motion to approve.
Well, you need to open a public hearing. First
I'm sorry.
Don, will you please let me do my job? My God. Okay, I'm going to go ahead and open the public hearing. I see two members of the public and a former mayor and current councilman.
Got to come up.
I don't have any cards on this. Anybody want to be heard? Okay. I'll go ahead and close the public testimony portion of the public hearing, and we'll open it up for commission discussion or a motion. Now would be the time for that.
Can I do it now?
Please.
I'm going to make a motion to approve.
Motion by Holtz. Is there a second?
I second it.
And would you like to remove the 15-foot rear setback?
Yes.
So this, for all intents and purposes, eliminates the AHQ from our vocabulary?
Yes, yep.
Because it's kind of outdated and been supplanted. Okay, any further discussion? Nope. Then let's have a roll call on this motion, please.
Commissioner Holtz? Aye. Commissioner Hing? Aye. Commissioner Kennedy?
Aye.
Commissioner Arquez? Aye. Chairman Redholz?
Aye. Motion passes 5-0, and this is appealable too, isn't it? Within 10 wonderful
Well,
days.
it's not appealable. This is a code amendment. It will go to the council for their
got it,
decision.
got it, got
So
it.
you just provided a recommendation.
We sure did. Okay, thank you. We will now move on to item number 3. Was that 3? Oh. No, this is 3. We're going to do 3 now. Oh, we did 3? Oh. Oh, you're right. All right. Got to go back to, we can do it, exactly. All right, we're moving on to item number 4, which is another code amendment. Number 1903, a general exemption. The applicant is, the city's busy tonight. City of West Covina is the applicant. And, and let's have the staff report. Who's going to do that staff report?
Our planning assistant, Camelia Martinez, will be presenting that.
Very good, thank you.
Good evening, commissioners. This is going to be really quick. Before you is Code Amendment 1903 for temporary signage in the public right-of-way. So the proposed code amendment will consist of sections 26-312 and 26-314 to allow temporary non-commercial political signs to be placed in parkways within the public right-of-way. On April 2nd, 2019, City Council initiated the code amendment to revise the code, and on July 23rd, 2019, Planning Commission had a study session. And at the study session, Planning Commission directed staff to prepare the code amendment. Staff did prepare a draft code revision in that paragraph below, basically stating that signs shall be attached to the ground, shall not exceed 30 inches in any dimension, and shall not exceed 3 square feet in area, and have to be within the public right-of-way. If the Planning Commission chooses to recommend approval for the proposed code amendment, City Council will hold a public hearing to consider adopting the proposed amendments. If you have any questions, we would be willing to answer them.
Yeah, I have a question. As far as, we as a city do not impose a time limit on that, right? That's imposed by the FPPC, I believe?
There's not, we don't have a time limit on there. Keep in mind that this is temporary non-commercial signs. Although we even call it political signs. It's not just political signs. It's any non-commercial sign. So you can't put a time limit on a non-commercial sign.
Right, but we are using the word temporary.
Right, because it's a temporary sign. It's not a permanent sign.
Not permanent sign. Okay. And what's an example of a non-political?
Non-commercial.
Yeah.
Open house.
Oh, okay.
Or even open houses. I think is the best example I can come up with off the top of my head. But even a stated position on something like stop or let's speed up global, warming or something like that.
Okay.
That would be.
I'm not sure anybody's going to
post that, but.
Okay. Any other questions of staff? Nope. Anyone from the public? Nope. Close the pub. Oh, go ahead.
I'm full of questions tonight. I'm not sure why, but this particular political sign or signage for temporary, was it not allowed in the past?
It was not.
It wasn't.
The code currently does not allow temporary non-commercial signs in parkways. So it allows them on private properties. It doesn't allow them in parkways, which is the area, between the private property and the street. So yes,
it was not allowed.
it's not allowed. And that's only been a very short time. I think maybe about 4 years ago they changed the code to not allow that. The previous
but prior
council.
to that it was allowed.
Yes.
So prior to 4 years ago it was
I believe
allowed, and now 4 years ago it was not allowed, until now we're allowing it back.
That's the idea, yes.
I see.
And the parkway doesn't belong to the property owner, correct?
Parkway does not belong to the property owner, that's correct.
So could, when Councilman Johnson runs for re-election, can he just come by and stick a sign in that parkway?
I don't think I have the capability of answering that question any more than I can answer a lot of questions on political signs. I think there is some control that you can exercise over that area in front of your house, but it's not your property.
I mean, if you don't ask, some landscaping guys just yank it out and toss it by the end of the week.
Because you are required to take care, maintain it. So if it's a lawn and you're mowing it, you've got to move it to mow it. So, you know, there's a sort of a interplay of things going on there.
And the signage costs money, so I don't think you want to do it without their permission.
Right. Any other questions? Is there, did I close the public? I did close that. Okay. Then is there any further discussion or a motion on the item?
I guess I'll make a motion to approve.
I like it. Is there, I'll second it. We have a motion and a second. No further discussion. Let's have a roll call, please.
Commissioner Holtz? Commissioner Hing? Commissioner Kennedy? Commissioner Arquez? Chairman Redholz?
Aye. Motion passes 5-0. We have now taken back control of those parkways. All right. Now, ta-da. Moving on to a non-hearing. Are you okay? Okay. Moving on to a non-hearing item, which is item number 5. And let me go back over here. This is initiation of a code amendment, number 19-06, general exemption. The applicant, once again, City of West Covina, citywide. This is a request to initiate a code amendment, number 19-06, to allow the West Covina Municipal Code to be amended to be consistent with state law pertaining to accessory dwelling units. May we have the staff report, please?
Yes, as just described, this is being brought to you because the state passed some bills and we're reacting to that. Our city attorney's office has been looking at this pretty, putting great scrutiny on it over the last couple of months because this didn't come into effect until, what was it, October? When the governor signed it. So we don't have a lot of time, you know, when the state does that to us. So they're now working very diligently to get it in place, and there's certain things that, and I've listed some things, I'm not necessarily planning on going over them, but if you have some questions, we might be able to answer them in a general sense, because some things that the state law, the new state laws do. And generally, they also, I think, put a requirement in there that they take effect whether the city does something or not. So we're trying to, the city attorney's office with the city is trying to work towards getting to be in compliance with that. To do that, we can't necessarily follow the normal process. We wanted to get it initiated tonight because the idea here would be that it would go to council under an urgency ordinance sometime, well, it'd be the 17th of December, if we can accomplish that, which would allow it to be in place before the beginning of the year when staff will probably be deluged with lots of questions from people wanting to do these things. So that's sort of the general gist of how we see this is going to go. I would say one other thing. It is my intent to come back after that with more of a discussion, study session on reaction, if there's things we can do to sort of cushion the blow or soften that blow. I think there may be some things. I haven't had a chance to vet them out with the city attorney's office because they're very busy trying to get us in shape for January 1st. But that is the intent here, not necessarily just to adopt those standards and move on, but to adopt those standards and come back and see if there's anything we want to change in our zoning code that might soften the blow, I guess. That's how I put it. So we'd be looking for a motion and a second tonight to initiate the code amendment as required by the code.
All right. Well, before we do that, I got a couple of comments on this. You know, we've been dealing with the ADU situation for a long time, you know, going back and forth and like a ping pong table. And I think we all have to realize that this is a paradigm shift. This is a monumental power grab, in my view, by the state. Okay? They have completely taken away this city and every other city in this state their ability to actually control their neighborhoods. This essentially eliminates single-family housing. And You talk about local control, we just had it yanked out from under us. And, okay, all that, great. Problem that I see, we understand why they did this. There is a housing shortage. There is an affordable housing shortage. No one disputes that, okay? Most cities are built out. Most housing being built is, there's requirements for a certain percentage of, low-income housing. All that's great. But the problem is, in my view, the state, there was no opportunity to even discuss this. There's no opportunity to mitigate, no opportunity for the city to work with the state, to come to some sort of meeting of the mind to address this so the state could still, so the city could still maintain a modicum of control of itself. That's all been taken away by the state. And I have concerns. This was just done in October. I mean, it's not even dry. And here we are dealing with this with a gun to our head, in my view. And the first questions that came to my mind is, we're part of the League of California Cities. There's other organizations that are supposed to be working together to help each other out. This really, to me, flew in under the radar. It's like, where did this come from? And now all of a sudden, we're dealing with it. And this is devastating. And I'll tell you, it could have been perhaps a little palatable, a little bit. They eliminated the owner-occupied requirement. It's gone. Now, guess what? It becomes a spec market. Developers, people that have no interest, don't care about West Covina. They're in it, for the buck, and that's fine. Be in it for the buck. That's what people go into business for, and buy land, develop it, and so forth. But by not having that owner, the owner didn't even have to live in the main house. The owner could have lived in the ADU. Didn't matter as long as they were on the property. Now that requirement is gone. It becomes a 100% spec market. Guess what? No more minimum lot size. Gone. No more garages. You don't have that parking. Do you realize what that's going to do to the street parking? This, in all the years I observed Planning Commission, all the years I've been sitting on here, this is the worst thing I've ever seen. It's really devastating. We fought for local control with our fire. We fight for local control here. I think most of the residents are in agreement. City needs to be in control of its destiny. What happens here? The state came along and just pulled the rug out. No opportunity for discussion, no opportunity to be heard, nothing. They just did it. And now we've got to dance to their tune and get this in front of the city council by January 1st. Is there a grandfather opportunity here? I read somewhere where there's a possibility of being grandfathered in with some aspects of this. Maybe I read it wrong. Maybe I'm dreaming. I don't know. But is that something that is...
Those are things that we're looking at right now. And when we come back with an ordinance, it'll...
All right. So we'll see. But anyway, I'm just blowing off steam because I'm mad about this. I'm mad about this. And, we talk about hearing from the public. As Vice Chair Hing, we need to hear from the public. We do. We always do, and we should. But when you don't even have an opportunity as a body and as a community to discuss this when it's already done, and I'll tell you something else. I called our elected representatives in the Senate and the Assembly. Now, these bills were originated, I believe, 100% by Northern California legislators. Okay? So I called our local people, a couple of them, few of them served on city councils. They all voted for it. I think one of them voted against, one minor, I think it was 68, voted no. Everything else was yes. I'm not happy about that either. You know, they didn't vote, in my view, to protect their district. At least, and again, I get it. It's a housing situation, understood. But there's a way to address these things without completely taking control away from the city 100% and taking that owner-occupied out of there and taking the garage out of there and taking the minimum out of. I mean, it's just really devastating, and I'm disappointed in the way it was handled. From here to Sunday, I'm not happy about it. Any other comments on this? Commissioner Jaquez?
I don't know how to follow up with any more than what you've said already, other than this grotesque, Orwellian chess move that the state took to take away our local control. I think the only thing I could add to what you said is that it's not going to stop there. It's not going to stop there. This is just the first step of a much more onerous approach to planning a more densified, urban center in places that we never in our lifetimes thought would happen. But it's coming. And as you said, by taking away the owner occupancy requirement and creating this spec market, the forces of the market will take over. They will take over to the point that it's going to push, it's going to push things in a direction where even greater density is going to be forced upon us. And the neighborhoods that we knew and loved in a city like ours are going to be gone. And like you said, I'm just befuddled as to how our own state legislators or representatives here voted for this thing. And, coming from, this part of the San Gabriel Valley, having, probably had the same sort of history of growing up here and enjoying the character of the types of neighborhoods that we lived in, and gave it no thought as to what it was going to do to future generations. It's frankly sickening. And I just don't know what to say except for watch out for the next chess move. The next chess move is going to force more and more density on us, and it's not going to end. It's part of a greater grand plan to avoid building new housing where it can be built and transforming existing communities because of some twisted vision that some people have, and that's what it really is. It's a twisted vision.
Well, just to, most of us have spent our time on the Planning Commission with a goal of maintaining the character of our neighborhoods, not letting them. We fought, mansionization and McMansions, and we tried to maintain stability and character in these neighborhoods, especially the established legacy neighborhoods, and all of that is now gone. And it's just, I could go on until I give myself another ulcer, but I don't want to do that. Any other comments? So what's, oh, sure, you can be heard on this, absolutely. I'm sorry, yes.
That's being said. I just want to know, by asking Jeff and staff, I have a relative that sits as a city planner and senior city planner in another city, obviously. But anyways, he said their city is looking at enforcing that when these ADUs come in, that they require, their city require, they're looking at it, they haven't put it down, that these new ADUs have to have independent hookups to public water and sewer systems, that they can't run off of the first house. And secondly, because we have to make sure we have adequate water for these, and that's always been our problem in California. But also have view ordinances put in place, because you guys have all been hit with people that have, the view's been obstructed. So that is also what their city's looking at. So when they're looking at, they're going to protect the existing neighbor by protecting their views. And when these ADUs come in, that's how they're going to work around this 68, 881, and they're trying to put those in there. And trust me, these other cities like San Jose, San Francisco, they're going to protect their properties and their neighborhoods, and so should we try. So just thank you for allowing me to inject that. Thank you.
Yeah, thank you, Angie. Jerry, anything from you on this? Not tonight. Okay.
Too depressing.
Yeah. Is that something, what Angie brought up, is that something that is?
Well, I think that we made notes, and we'll be looking into those things. I want to give a lot of credit to the attorney's office. They had to read if you try to read these things, I mean, it's like reading a dictionary, it's not, and they've got to try to make heads or tails out of it. They're working very hard with several cities that they're working with, so they'll be looking at those things.
Okay, and I appreciate that, because I looked at the actual bills, and, pulled them up, and man, oh man. I mean, they write that stuff to make it impossible to even deal with. And it's not written by, I'll tell you what, we know it's not written by the elected. No, they don't write this stuff. It's those people, the lobbyists and the activists and all that write this stuff, and they hand it to a legislator to get a signature on it and a sponsor and so forth, and have it go through the pipeline. But, something as monumental as this to be completely under the radar it's just unacceptable. And believe me, these electors are going to hear. And some of them are friends, and they're going to hear it louder. I don't care. Anything else?
I actually like to add something. A few years back, I believe Commissioner Holt, our chairman, myself, Brett Holtz, and other commissioners were at the city's league, and one of the discussion that they were talking about at the time was, you had mentioned that all these codes were initiated from the Northern California, and apparently one of the discussion a few years back, which is possibly 4 or 5 years ago, and their city has an issue, the Silicon Valley in particular, Santa Clarita, Santa Clara, San Jose, a lot of other cities around that area. They have an issue that they were talking about it. It was hard to believe at that time that 3/4, which is 3 out of 4, is living not in where the city that they work at, whether it's Santa Clara, San Jose, what have you. So during the daytime, they have 100% of the people there. In the evening, 3 out of 4 has to leave those cities to go find a place where they live, and they have to drive. And that was a driving force, and it's an issue. I guess we don't have that problem here. Hopefully not. But we don't have a job market that demands so many people to be in that area. And to be honest, I live here almost, 30-something odd years. I have not seen freeway added, but population keep increasing, not regarding just the job market and focusing in a certain area. But that was an eye-opener a few years back regarding the population increase. And as planning commissioners, if we're not in tune with these type of numbers, it's really hard to believe. Even sitting here today, is it hard to believe that these codes are coming into play? And what our fellow commissioner had also mentioned, that all these code initiations started from Northern California. is part of the reason is that they have an issue. They have a lot of jobs with no housing for their employees to live in the city that they worked in, and they have to commute, whether it's commuting outside. So they're trying to find a way to mitigate their employees, and that's how our state make money as well, income tax from all the people who's making or working in their cities. So, I mean, I don't have an answer per se, but it seems like it's not just all of a sudden that it shows up. It's hard for me to believe, but then yet at the same time, not really, because this was addressed 4 or 5 years ago. Not in our city per se, because we don't have such a huge job market, but Northern California do have a huge job market issues in a housing crisis. I don't fully understand why we have an issue throughout the entire California. And also at the same time, this housing issues not just arise today. 20-something years ago, California the Housing Authority, I believe, had written articles regarding the fact that we're getting into these issues. That's 20 years ago when I first read it. I'm not a planner, it's just a resident. It's just hard to believe that something like this can happen. And I guess as a city and as a commissioners or as a resident, we had fought it for the last 20-something odd years. ADU just didn't come out today. I believe the first one was 2003 or 2002 when it first, it's a long time ago. Basically, I read on this a long time ago. So it took 20 years for us to resist ADU, you can say. Like I said, the article was written predominantly to address the aging population. But I didn't anticipate that a few years back, it wasn't the aging population that the northern city was encountering. They were encountering the job market population. And we still have the aging population that we also have to address. I mean, that's something that we need to take care of. Even today, if you ask me, would I see homeless all over the place today? I wouldn't believe it. And that, to some extent, may be tied. Okay, there's a whole slew of things regarding homeless issues, not just the housing issues. But these are things that we either, one, had to, as planning commissioners, we have to see within the futures and see what is the problem that we have. I mean, sometimes it's a good problem. Sometimes it may not be a good problem. It's just like some city, they don't have a job market. And even if they give you a house that's, $5,000, $10,000, nobody wants it because there's no job market. We have a huge, I don't know how you looked at it, whether it's a problem or whether it's not. Northern California do have a job. They have a lot of jobs, and they just don't have housing. So that can be a problem. But some cities don't have any jobs, and they have tons of housing, and no one wants those houses neither because of tax issues and city, impound of fees and what have you on it. So this is an issue, like I said, not sure how we're going to address this tonight or in the futures, but it's been oncoming for a long time, and we either had to face it somehow, looking at the numbers, and come up with the ways that will work for us. Thank you.
Yeah, thank you. And I agree with that. I just don't see why it needed to, be a blanket thing to, just cover every single city. If they have issues they can deal. I mean, Burbank's the same thing. Burbank's population more than doubles during the day, as opposed to who lives there because of the entertainment, industry that's based there. The population's huge during the day, and then, at night it's like just the residents are there. But anyway, and we can debate this forever, and it can change. So we're looking for
a motion second to adopt the resolution to initiate the code amendment.
Is anyone willing to make that motion? Crickets. So what do we do if there's no motion?
Well, as Mr. Jeff's indicated, applicants are going to be subject to the state standards. So putting an ordinance is your, initiating this resolution to have us bring forth an ordinance is your opportunity to do what we can under the existing law. If we don't move forward, then you roll on the dice and we just have to be subject to whatever the state passes, including what they pass again in the future.
Well, we're subject to the state with or without it, right?
Well, we are, but as Barron indicated, there's things that they're looking into, and we can't, if we look into things and decide to try to incorporate them, we need the code amendment to do that. We can't incorporate any of those things without the code amendment. So basically, if we don't adopt the code amendment, we are, I think I would suggest you look at it this way. We're just basically giving up and say, let the state do whatever they want to us.
And to be clear, you're not approving tonight what the state did. You're just giving us authority to move forward and explore what we can do.
Okay?
I move approval.
We have a motion by the very brave Commissioner Jaquez. Is there a second? You know what, I'll go ahead and second it. Roll call.
Commissioner Holtz? Aye. Commissioner Hing?
Aye.
Commissioner Kennedy?
No.
Commissioner Jaquez?
No.
Chairman Redholz?
Sorry.
Man, I'll tell you what, I mean, I want to vote no.
I'll change my vote to yes, only because I understand what our attorney tells us as this is we're in a catch-22, and we'll go with the lesser of two evils.
So you're
I'll
changing
change my vote to yes.
Aye? Yes. Then I'll vote no. I do feel a little better.
I can't vote yes.
And keep in mind that when you initiate a code amendment, all we're doing is you're giving us direction to go study it. When we come back, then that's a different question. Then you're adopting something. Okay. So, but in this case, you may not be adopting it anyway because the council may do that through an urgency form. So it may not be till we come back with some ideas to try to soften the blow that you have a chance to weigh in.
All right.
So I appreciate the angst on that. I think staff is feeling it as well, but sometimes you just have to follow through, and sometimes you just try to make do with what you can, and I think that's sort of where we're at. Let's try to salvage what we can out of the situation.
When will the council hear this?
The plan is on the December 17th.
Okay.
And sometimes you just got to make a statement. What do we have left? The study session on specific plans? That won't take very long, I don't think, will it?
Well, that,
Or do you want to postpone it?
Yeah, postpone it, please.
That's two good decisions Jaquez has made tonight.
You owe me a beer.
I do. I'd be happy to pay it. Okay, so we're at what? City Council Planning Director's Report, or what are we at? Okay. Community Development Director's Report.
what we have on there tonight is the forthcoming. We do have several items for the meeting of the 10th, which will be the last meeting of the year. We have several, they're all several public hearing items, and we have the presentation of our historic resources inventory that someone's been working on for the past year. So plan on that on December 10th, and then you can have the rest of the year off. That's all I have.
City Council action? There was anything?
Don't have anything to report on City Council.
Okay. Then,
Jeff, I have a
yes.
quick question, though. These videos that's being seen. Sorry, here you go. I guess my question is these videos that's being seen, outside for the residents and what have you, who is running? Is it a company that is running this?
Who does the YouTube video?
Yes.
Oh, yes, we have yes, there's somebody that runs it.
I know somebody who's running it.
Well, I'm not even sure what the connection is, but they're part of the city's organization.
Nonprofit, volunteers,
No,
or
they're not volunteers.
they're not volunteers? Is it city staff? I
I'm
just
sorry.
assumed that it might be a
I know
vendor.
you may think I'm vacillating. I don't know the answer to that. I don't know if Mark does.
They're part-time staff through IT.
Okay, so they're part-time employees
The part-time employees
of the city.
through IT department? I see. Thank you.
Okay. We've reached the point of adjournment, I believe. I just want to, before we do that, the City Council adjourned in memory of a gentleman named John Schuplin, who was an activist in this city for many years, and he also served as a planning commissioner for a long time. So I just would like to adjourn in his memory. And I'd like to wish everyone a happy Thanksgiving in a couple of days and wish myself a happy birthday on Friday. So, so with that, we are adjourned.